Hi, my name is David Shapiro, San Diego-based criminal defense attorney, and today I want to talk to you about California Penal Code Section 314, which is known as indecent exposure. Indecent exposure is a very serious charge, albeit without any prior criminal history and without any prior indecent exposure convictions, can only be charged as a misdemeanor, if that's all we're dealing with here in the state of California. However, if convicted of indecent exposure, it is mandatory that you register as a sex offender for the rest of your life. There is no discretion, there is no wiggle room within that mandatory lifetime registration as the law currently stands. A lot of times people may ask me the question, is it enough genitalia? And it's not, because you need to be exposed doing something for the purpose of sexually gratifying yourself or others, and you need to do something to draw attention to yourself. So, I had a case earlier this year where it was undoubtedly a situation where my client was touching himself and masturbating in public. But the issue was, and it came down to, whether or not what he was doing was drawing attention to himself, trying to draw attention to himself. In fact, the opposite was true, and a jury agreed with that. Whereas the city attorney had no issue, the prosecutor had no issue proving that it was a lewd act in public, and we conceded to that fact. It was not indecent exposure as written under the law because he did nothing to draw attention to himself when he was exposed. In fact, there was a video in the case and it showed that it was only when people weren't around that his genitalia was exposed. When people were around, his genitalia was not exposed. And that situation, at first glance, a lot of people say, what do I need a lawyer for? They got me. I'm on video. Or hey, indecent exposure could be this. Well, why are you going to fight it? At first glance, a lot of people said to me, you're crazy. You going to trial on this case? Your client's going to trial. More importantly, your client's going to trial on this case? And I said two things. I said, one, we're not getting an offer, so I'm not going to plead my client to a misdemeanor that's going to make him register as a sex offender for the rest of his life. That's the first thing. And the second thing is, if you scale back the public perception, if you scale back what the charge is and the ooh and the ah about that, and you actually look at the law, I don't think this case can be proven. 11 of the 12 jurors wound up agreeing. The case ultimately was determined a hung jury. It was 11-1 for not guilty on the indecent exposure count, and that case was ultimately dismissed. And as a result, that person who was exposed and masturbating in public does not have to register as a sex offender for the rest of his life, and he's undergoing current treatment. So that's an example of how, with the right attorney who knows what they're doing, who has the experience in these types of cases, and who's not going to just, enter a plea because they might not want to go to trial, or they might not want to do the research and the legwork into it, or they might not want to go to trial and talk about subjects as sensitive as these. If you hire the right person, you could win these types of cases. You could avoid lifetime registration as a sex offender when you examine the elements of the offense. That's why it's also essential, when questioned by law enforcement about this and they start asking about what was your intent, was it for sexual gratification, did you attempt to draw attention to yourself, all those types of things. If they're smart and they're skilled interviewers, they're going to basically try and make you admit to the elements of that offense. Keep your mouth closed, get a good attorney, and these cases are winnable.